The CPI report, Child Protection in Iowa, brought to you by Vocal, Victims of Child Abuse Laws. You can watch the program on Mediacom Channel 15 on Sunday afternoon at 1 o'clock. Again, it's aired Wednesday evening at 9:30. You can email us at vocal.iowa@mchsi.com, or you can call us. My number is 515-276-3956, or John's number here in Des Moines, Iowa, 515-282-2672. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report. CPI, that stands for Child Protection in Iowa, and it's on these particular issues that we spend a good deal of time in two different ways. One is to influence public policy, and one is to work directly with parents who call for our assistance, who are having difficulties in the Department of Human Services or with juvenile court. There are a number of things that are involved with these relationships. For some reason, the department and the juvenile courts have one agenda, and parents have a different agenda that has been in place for a few millennia. But it seems as though one of the agendas operates on the principle that the state or the government is the better parent. And quite often this comes into conflict with the way we try to do business as families. There's no better place for a child than with a family. It was by design that we have that family structure, that mom and a pop, and Dick and Jane and Puff and Spot. Not always the ideal family, but certainly a better situation. In fact, Don, in many of the cases in which we've worked, we found that when government messes around with the family is far worse off than it could ever have been imagined without the governmental intervention. So I'm somewhat wary every time I hear some new scheme that is supposed to be super duper helping families, some new project, and DHS, the Department of Human Services in Iowa, is famous for developing all kinds of new programs and structures and ways of doing things. It's amazing how they can get into lives. In this area of child abuse, 1/3 of all of the, it's 1/2, I believe, of all of the calls or all of the work that DHS does comes through the gateway of child protection systems. So it would not be wise to ever push for a system which would wipe out child abuse, would it, or diminish it. Why? Because to diminish it would mean to shut the door on the marketing division of the Department of Human Services. If they don't have those cases coming in, then there can be no services rendered and no employees to provide the services, no contractors to contract with to provide services, no influence for DHS to mess around with families. Wouldn't it be terrible if they had no cases and they didn't fill up all of the court dockets of our county? This would be a disaster. if ever they became successful at eliminating or discouraging child abuse. So they'll come up with all kinds of things, and we read on one of our previous programs about a real interest or desire on the part of Prevent Child Abuse, an organization that operates here in Iowa, to initiate or to ask for more funding for shaken baby syndrome, which some believe is one of those schemes to dream up abuse where no abuse has occurred. And they want to fabulously increase our efforts to eliminate shaken baby syndrome, even though there have been only 4 deaths arising from shaken baby syndrome in the past year. So when you get into what we term as junk science, you can spend a lot of money, spin a lot of wheels, and get nowhere fast. But because somebody comes up with a scheme, let's ride that scheme all the way to the end. Same with pharmaceuticals, same with a lot of other things that are happening in today's world. A lot of these things will be discussed in the General Assembly to be opening very, very shortly here in the beginning of January. Looking at all kinds of things. Last General Assembly, for an example, even though we knew that child abuse, according to the statistics, in the area of sexual abuse has dropped down to somewhere around 6% of the cases. And some of those I think you could probably question as to whether they should have even been considered child abuse or sexual abuse. But because we do have something that is a hot button word, they're able to extract more and more money out of the state legislature. And this last time around, they managed to get $200,000 to fight in a cause which is diminishing down to almost nothing. 6%. I think we should be concerned if there's 6%, but to pile on $200,000 from a state that doesn't that is not replete with funds is pretty sad reasoning in my way of thinking. Well, another thing that is very sad is when government decides that they're going to go against families directly. And this was not in Iowa, but Don, you've got a story to tell us about where they have decided to land very heavy hand of the law on a family that doesn't meet the standards that the government would like. Would you pick up that story?
Okay, you're referring to the defending a lawsuit against motion to dismiss. In March 2006, Homeschool Legal Defense Association filed a lawsuit in Arizona on behalf of a member family whose 4th and 14th Amendment rights had been violated by a social worker investigation that had no basis outside of an anonymous tip. Just a few weeks after our filing, that means they filed in the court for the benefit of the family, the social workers filed a motion to dismiss. The DHS hopes that the judge will dismiss it and then the lawsuit will go away. The motion to dismiss said that their actions were completely within the law. The family, Mr. and Mrs. Larby, whose name was changed to protect family privacy, denied a social worker access to their home at the first contact. But over a month later, 2 social workers and several sheriff's deputies arrived on their doorstep, insisting on entry into the home. The family immediately called HSLDA for help. That's the homeschooling legal assistance. The social workers refused to speak with HSLDA staff attorney Thomas Schmidt. Remember Schmidt, he's the HSLDA attorney representing the family. But workers refused to speak, I'll go on. But instead insisted that he talk with an assistant attorney general who informed him that if the Larbys did not allow the social worker into their home, the children would be removed from their parents' custody. The social workers also told Mr. and Mrs. Larby that if they were not allowed into the home to complete their investigation, they would handcuff the parents in front of their children and take their children away. Well, the social workers are being honest with the parents is what they'll do. Within 5 minutes, the social workers determined that the anonymous tip was false and left. So the DHS system concluded that it was a mistake in the first place. HSLDA filed a lawsuit in federal court on behalf of Mr. and Mrs. Larby for violation of their Fourth Amendment rights, interference with family privacy, and the sheriff's failure to train deputies in constitutional procedures. We argued that the wrongful threat to take custody of Mr. and Mrs. Larby's children was coercion, a tactic often used by social workers to gain unlimited access to a family's home, despite the parents' objections. Shortly after HSLDA filed this lawsuit, the social workers responded with a motion to dismiss, stating that they had not violated the Larby's family's rights in demanding entrance to their home and threatening arrest and removal of the children. Instead, the social workers argued that their actions were protected, claiming that social workers do not have to follow the Fourth Amendment when conducting an investigation. That's interesting. Some people have to follow it, some people don't. And the DHS thinks they don't have to. They asked the court to dismiss the case before the Larbys were even able to present any evidence showing their rights had been violated. HSLDA responded to the motion, arguing that all social workers are bound by the Fourth Amendment and citing HSLDA's landmark case, Calabretta versus Floyd. That's from the United States Supreme Court. The principle that government officials cannot coerce entry into people's houses without a search warrant or applicability of an established exception to the requirement of a search warrant is so well established that any reasonable officer would know it. At the same time, HSLDA responded to another motion to dismiss from the Assistant Attorney General who had spoken with Schmidt. Schmidt is the attorney for the HSLDA. HSLDA is responding to another motion to dismiss, which said that the Larbys had failed to state a claim at all. In our reply to this motion, HSLDA explained to the court that the Assistant Attorney General had indeed violated the rights of Mr. and Mrs. Larby with her statement that the social workers would take custody of the children under Arizona law if they were not allowed into the house. With the briefing on these motions now complete, we are awaiting a hearing date with a decision from the court as to whether we will be able to present the evidence that Mr. and Mrs. Larby's rights were violated. John, I got a question. At the top of that page it says the Larbys had failed to state a claim when the attorney for HSLDA filed the paperwork. What does stating a claim mean?
I think that's just one of the tricks that they use, failing to state a claim for which relief can be granted. It's just a defense tactic. It isn't something that would be immediately clear to pro se litigants, for an example, but it's just one of those delaying tactics, schemes that you put in if you're a defendant, just saying that the person who is accusing you or is bringing charges against you or has a petition against you, you just say, well, I looked over the petition and I don't see a claim for which relief can be sought or for which relief can be granted. It's just one of those silly things. I should mention, however, in Iowa, I don't know whether this is the case in Arizona because I don't know Arizona law, but social workers technically cannot remove children from their homes in Iowa. I think juvenile court officers can under certain circumstances, and I believe that there are other people who can remove the child. There's a doctor can keep a child in the hospital for a certain period of time and not permit the child to be returned to the care of the parent, but there has to be a court action to back all that stuff up. So when a social worker says, I'm going to take your children, she or he may be speaking the truth, but it has to be done through certain procedural due process steps. It can't be just a matter of them picking up the children and hauling them off. They would like to think they have that authority. And by the way, if you as a parent believe that they can do that, you see what that does in effect. It has the full force and effect of law. If you believe they can do it, and they go ahead and do it, who cares what the law is? So I think a lot of people are intimidated by what social workers are taught to say at the door. You don't have anything to hide, do you? Let us in, you know. You should say, not by the hair of my chinny chin chin, you know. You can knock all you want, but I do have something called Fourth Amendment rights to protect myself. You see, this story is illustrative of several things. It's illustrative of the violations of Fourth Amendment rights, which, by the way, have been enforced in Iowa against social workers, at least to the extent that they're supposed to have some lessons on Fourth Amendment rights. And HSLDA was heavily responsible for getting that piece of legislation into Iowa law, for which I am quite pleased. Secondly, HSLDA has learned a lot in working basically with homeschool families, but because they work with homeschool families and these people happen to be somewhat independent in their outlook on government and governmental interference, they run against social workers, they run against the juvenile court and others who believe that government can do no wrong, that government should have all kinds of immunities, that government is the better parent in the end. So they've come to know a little of what we've been working with for a couple of decades, and that is there needs to be some reform with the way we deal with these issues of child protection, and not use child protection as a means to rearrange families and to influence public policy. Well, we've been covering a number of the recommendations of the Department of the HSLDA, they've had recommendations, legislative recommendations, and we're going to finish those up today. But before we do, we're going to talk to a gentleman who is highly skilled in this area of court reform. He's watching the internet constantly for stories and for updates of what is happening around our country in order to bolster the good life. That is, the life that could be realized if only we had a court system that was fair and adequate. We have not seen that in a few decades. We've seen real corruption, and where I see it the most is in the area of the prosecutor's office, where the prosecutor could, if he wanted to show his power and authority in a county, since he is an elected official, he could incarcerate all of his enemies, and he could let all of his friends who do wrong go free. And there isn't a whole lot that you could do against it. You see, he has more authority than the king. With that, maybe I better mention one other thing before I turn the reins over here to our legal expert. Do you know that in the caucuses that have just been wound up here in Iowa, HSLDA surprisingly came out for a candidate, Governor Huckabee. And it is very heavily recognized that their influence in that election has pushed his candidacy very, very heavily. We won't know we don't know at the time of this taping whether that push is realized in terms of getting him into the final stages of candidacy. But at least HSLDA has taken a step to endorse Huckabee since he has shown himself to be the kind of person to back the homeschooling concepts. Now I notice that several other candidates have come alongside and are kind of interested in getting votes from homeschoolers. Well, HSLDA has grown tremendously, but they've grown as a result of an outcry for freedom, an outcry for the sanctity of the family, an outcry for the right to life. You see, those kinds of organizations are going to thrive in this nation so long as there are good people around. Well, talking about good people, let's switch to talk to Terrance Walker.
Thanks a lot, John. Well, I appreciate the kind words. I mean, you guys do a lot as far as it pertains to DHS and child protection reform, and I commend you on your efforts there, because I don't think there's anybody else that's voicing any opposition to what child protection is doing here in Iowa, as it pertains to, anyway, as far as their abuses and their abusive authority and their abusive practices. And that's what actually I'm talking about as it pertains to the legal establishment and the judges and the justice system. And I think that I did find a good article out there. It was on the northcountygazette.org website, and I think it highlights what they term is a judicial retaliation Ohio style, but I think that it pertains nationwide across the board, because I can recall many instances in which I as a reformer and activist have encountered similar conduct, and I'm sure you guys too, John and Don, and some people out there in the audience can relate to this story. Well, this came on the website of North County Gazette. So Ohio-based, actually Ohio-based website. Ohio, they deal with reform issues as well, and they had some good commentary on there. Posted on December 26th of '07. They highlight 3 different stories that highlight what can happen to you if you go against the grain and you expose abuses as it pertains to the justice system. This is Steubenville, Ohio commentary. He's talking about a guy by the name of Richard Olivito first. He represented a woman who was 8 months pregnant, publicly strip searched in a supermarket parking lot after she was falsely accused of shoplifting a chicken. He filed 5 lawsuits against the Warren, Ohio Police Department for violations of their constitutional rights of citizens and pushed for the U.S. Department of Justice to investigate the police agency. When a police officer confessed on the stand that Steubenville police had arrested his client not because of any crimes committed, but because they had been ordered to do so by Jefferson County Prosecutor Stephen Stern, a judge threw the case out of court. He sued the prosecutor, the police department, and Steubenville officials in '96, and they settled out of court. Not only did he win the case, but he convinced the U.S. Department of Justice to investigate the city of Steubenville. The Department of Justice found that Steubenville police had engaged in a pattern of retaliation and excessive force and placed the police department under federal supervision in 1997. For the past 10 years, and in particular the past 3, he, Richard Olivito, 48 of Steubenville, the son of a judge, has exposed the systematic corruption which exists in eastern Ohio and has spotlighted the egregious constitutional issues which exist in the police departments and prosecutors' offices, which result in false arrests and malicious prosecutions. But in 2005, the government lashed back, retaliating against Olivito, trying to shut down his legal practice after he filed 2 federal lawsuits against the city of Steubenville, alleging police brutality and excessive force, and after he undertook the legal representation of Brian DuBois, a blogger who had been charged with retaliation and intimidation of retired visiting judge Richard Marcus, along with his business partner, Dr. Elizabeth Baumgardner. In what has become the nationwide standard modus operandi of the government against whistleblowers and attorneys who dare to challenge and expose the police and prosecutorial misconduct, which has become all too prevalent across the nation, Olivito's fellow attorneys in the Bar Association and the court retaliated against Olivito, trying to label him as mentally unstable and to stop him from practicing law, to discredit him and make him an outcast in the legal and judicial community. In 2006, the Ohio Supreme Court suspended Olivito's law license for 2 years, with 1 year stayed after the Mahoning County Bar Association filed a disciplinary complaint against Olivito. He was eligible for reinstatement in July of '07, but on December 18th, the court continued his supervision from practicing law and found him in contempt of court for failing to get a psychiatric evaluation as ordered 3 times by the Disciplinary Commission. The court ruled that Olivito violated state attorney discipline rules by neglecting the bankruptcy case of clients Catherine and Michael Acola, forging their signatures on sworn court documents and making false statements to the Acolas and court officials in an attempt to avoid the consequences of his misconduct. The board also claimed that Olivito attempted to withdraw from representation of the Acolas and without giving them without giving them proper notice or taking reasonable steps to protect their legal interests. In setting a sanction, the court noted the mitigating factors, meaning that, these are surrounding circumstances that may have went in his favor. For those that don't know what mitigating means, they noted that Olivito had no record of prior disciplinary violations, that his improper actions affected only a single case, and that he had acknowledged the wrongful nature of his forgery of his client's signatures. In their decision earlier this month, the court said that Olivito won't be allowed to apply for reinstatement until he complies with the court order to submit to an evaluation to a Cleveland psychiatrist, apparently one chosen by the court. And you know how that works. If the court chooses the court can kind of sway the decision one way or the other. Now, they don't say that, but, it typically happens that way. And that's one example that they listed in this article. Now, typically, if an attorney gets some sort of they have something against them that they do that's wrong, they get a second chance. They get a reprimand. They're back in business. But and they didn't give him a second chance. They give him right away. And they even recommended that he do a psychiatric evaluation, which plays absolutely no role in the matter because it didn't look like he did anything that was crazy. Anyway, on to the second example. There is another lady by the name of Dr. Elizabeth Baumgartner, who Olivito had represented. Dr. Baumgartner has been a longtime critic of the Ohio government, both local and state, alleging massive federal and state grant fraud as well as abuses of power by public officials, particularly Erie County District Attorney Kevin Baxter and numerous judges in the northern Ohio region, especially retired visiting Judge Richard Marcus and Ohio Supreme Court Chief Judge Thomas Moyer. In November of 2005, as Olivito was trying to represent Du Bois in pretrial motions before Cuyahoga County Common Pleas Court Judge Shirley Strickland Saffold, the Supreme Court of Ohio's Board of Commissioners on Grievances Disciplines recommended that Olivito be suspended from practicing law with 1 year suspended. It was enough to force Olivito from the Du Bois case. At the same time, Saffold arbitrarily revoked the bond of former attorney and pharmacist Baumgartner and sent her to jail for 3 days without stating a reason for her arrest on the record, which they're supposed to do. Court officials later tried to claim it was because Dr. Baumgartner had disrespected the court, but the court record fails to support that claim, especially since Saffold had adjourned court and left the bench. Du Bois, then 28, editor of ErieVoices.com, a blog which focused on judicial and political corruption in northern Ohio, and his associate, Dr. Baumgartner, 50, who were charged during the summer of 2005 with multiple felonies in a secret indictment obtained by Assistant Prosecutor Daniel Casares, whose boss, Cuyahoga County Prosecutor Bill Mason, had been the target of the blog's allegation. Olivito, too, had been critical of the government in blog postings as well as his court filing. In December of 2005, Saffold again jailed Dr. Baumgartner, ruling from the bench without medical advice that she was mentally traumatized, sending her to jail without treatment from December 12th to 20th, according to the records, and without stating on the record the cause for Baumgartner's incarceration and without a hearing. It appeared as though Cuyahoga County and Judge Saffold had closed the case against Baumgartner by denying her constitutional right to trial and without any medical diagnosis. Instead, Saffold rendering Baumgartner incompetent without any hearing or any evaluation by medical professionals. Baumgartner had been ordered to undergo a psychiatric examination during the summer of 2005, which she passed. In fact, she has passed 7 such examinations. She says that according to Ohio law, the competency hearing had to be held first, not last, as Saffold did. The case of Baumgartner and Du Bois evolved around the free speech right to criticize public officials. The duo had been charged for allegedly intimidating and threatening visiting retired Judge Richard Marcus in the fall of 2004, based on a complaint made by Marcus, albeit not until months after the alleged incident, and after Marcus had ruled against Baumgartner in a civil case, imposed a $175,000 judgment against her, and then cited her for 34 counts of contempt for criticizing. Now, there's what's that?
So much for the First Amendment, huh?
Yeah, well, you can't criticize a judge, I guess, is what they're trying to say. Now, the judge, actually the prosecutor that charged Baumgartner, Casares, and Du Bois in 2005, one day after Du Bois filed a grievance against Casares and Marcus with the Cuyahoga County Bar Association, he indicted him. During a court appearance by Baumgartner, when she questioned the indictment, Judge Saffold said that she had never seen a prosecutor obtain an indictment because of criticism of a public official, as Casares had done. According to court records, Caceres' only argument in attempting to dismiss Saffold's questions on the validity of the indictment and the cause for it was that nobody seemed to have a problem with it except her. After Baumgartner was incarcerated by Saffold in December of 2005, Du Bois turned cold against Baumgartner and took a plea, and later he and his wife became a complainant against her. Baumgartner eventually pleaded no contest on conditions that she could remain free on bond while she appeals the case on constitutional grounds. Saffold has sentenced her to 8 years in state prison. Courts, actually, despite attempts by Caceres and Cuyahoga to stifle Baumgartner's appeal, her appeal brief was filed in September, and they're supposed to file another brief. I guess her rebuttal brief is supposed to be filed on December 27, which is already passed. And there's another guy that's actually in the fold when it pertains to Ohio retaliation of judicial style retaliation. But anyway, earlier this month, Venice, California civil rights attorney Stephen Yagman was sentenced to 3 years in federal prison for tax violations. 6 of the money laundering charges that the government had levied against Yagman had been dismissed. Yagman had a successful career winning civil verdicts against various law enforcement agencies. As reported by the Argonaut, a newspaper published in Southern California, 2 of Yagman's most published trials were actions against the federal government. In 2001, he was appointed as a special prosecutor in the Ruby Ridge case, in which he prosecuted the FBI agent who was on trial for killing the wife of white supremacist Randy Weaver. In 2002, Yagman filed the first 2 federal lawsuits against the government, which challenged the Bush administration's policy on detaining prisoners at Guantanamo Bay. Yagman later won the case, which granted prisoners habeas corpus or access to the federal courts to contest their detention. Yagman told the Argonaut that he was not surprised that the government had brought the tax case against him. I have always believed that I had painted a target on my own back due to the types of cases I had handled, and that heavy artillery would be used. Of course, the U.S. Attorney's Office dismissed the notion of retaliatory prosecution. A new whistleblower support blog was launched last month by the National Whistleblowers Legal Defense and Education Fund to provide critical information on cutting-edge whistleblower issues and breaking news stories related to whistleblower rights. The new blog, entitled Whistleblower Protection Blog, is located at www.whistleblowersblog.org. The U.S. Supreme Court handed government whistleblowers a setback in May of 2006, in a case when it decided in a 5-4 vote that such whistleblowers are not protected by free speech when they face employer discipline or for trying to expose possible misconduct on the job. The court ruled against Richard Celebos, a California prosecutor who said he was demoted, denied a promotion, and transferred for trying to expose a lie by a county sheriff's deputy in a search warrant affidavit. The court adopted the argument of the Department of Justice and the Los Angeles Prosecutor's Office that a public employee doesn't have the First Amendment free speech rights when performing job-related duties.
So much for the First Amendment.
Crazy.
Yeah.
The decision brought criticism by the ACLU, whose spokesman opined that in an age in which excessive government secrecy, the Supreme Court has made it easier to engage in a government cover-up by discouraging internal whistleblowing. Courts such as the Ohio Supreme Court have increasingly gone on the attack against solo practitioners such as Olivito and Baumgartner, who have outspokenly challenged government wrongdoing and police corruption, as well as newspapers reporters and others who have helped expose corruption in government. One of the most often used weapons being an attempt to discredit the person by claiming without substantiation a psychological problem or mental imbalance. Given the game plan and well-established modus operandi of the government, it's no wonder that Olivito wants a second opinion before subjecting himself to a psychiatrist chosen by the court to determine if he's fit to practice law. People's faith in government is at an all-time low. Stopping public corruption must be given the highest priority instead of government using lawyers, disciplinary agencies, and law enforcement agencies to target and attempt to discredit and undermine those who are attempting to expose the wrongdoing. The public's business must be open and accountable with tougher penalties for the violators themselves rather than killing the messengers and those on the front lines targeting and exposing the instances of improper influence and corruption. The public needs more people like Richard Oliveto, Elizabeth Baumgartner, and Stephen Yagman, who have made the sacrifices to root out the corruption, to defend clients whose civil rights who have been egregiously violated. It's not them the public needs protection from, but rather the judiciary, the prosecutors, and the corrupt members of the law enforcement, which seem to be multiplying at an alarming rate. Citizen confidence in the judicial system requires that judges, lawyers, and clerk courts, as well as others associated with the judiciary, maintain the highest ethical standards. These ethical standards are sadly lacking in our judiciary. When you have foxes guarding the henhouse, the outcome is inevitable. So are the majority of decisions by the disciplinary committees for lawyers and judges. The committee members cover for each other. One lies, the other one swears to it. It's kind of like they do in court. Across the nation, judges, prosecutors, and the police are running amok, engaging in a rape and pillage of the U.S. Constitution, abusing the laws, their briefcases, gavels, badges, and their black robes to terrorize, retaliate, and intimidate members of the citizenry who have the courage to stand up against their arbitrary and wrongful arrests, malicious prosecutions, and rulings, who seek to expose the cover-ups of abuse and corruption in the justice system and challenge the abuse of parties whom appear before them seeking justice and redress of grievances. Police are abusing their powers, arresting people who dare to criticize the government, arresting people for taking pictures of police officers, or simply taking pictures in public places, or, might I add, who refuse to give their name, like John III,
Yeah.
or who wear a T-shirt bashing President Bush, and for reporters who dare to look further than the news release handed out or the press release handed out and work to expose government corruption. The prosecutors and low-level courts are condoning it, resulting in ruining people's lives, causing wrongful incarcerations, trying to label their critics as cuckoo, all in the effort to cover up their wrongful actions, in essence fueling the cancer of governmental interference and corruption that has become pervasive in today's society. It has to stop. The allegations of systemic and systematic corruption in the state's court systems and specifically in the attorney disciplinary committees, which are charged with overseeing the ethics and integrity within the court system, are serious and troubling, documenting the need for not only an overhaul and review of the system, but a federal monitor to oversee the court systems of the various states, to undertake reforms and restore integrity to ensure that our nation's court system is transparent, accountable, and ethical and corruption-free. The same U.S. Constitution on which the judiciary bases its claim of judicial independence is the same U.S. Constitution that grants reporters, lawyers, and everyday citizens not only the right to express their views without retaliation, but the right to perform their jobs and professions without retaliation. And I couldn't have said it much better, so that's why I just read the article word for word on that case.
Excellent. What organization is that?
That's the North County Gazette. They got a website at www.northcountygazette.org.
Okay.
And they do a good job at
Beautifully
bringing out
written.
some of the stuff. Yeah, I think so. And that's all I had for this week. I
Okay.
think you had a little bit of something to share, so I didn't want to take up all the time.
Okay, good enough. Well, this road back, road back to reform of the courts is going to be a long, tough road. I think it's not going to come very fast because it's taken us quite a while to get to the corruption level of corruption that we're at right now. And I think it's going to take a tremendous amount of effort to rid ourselves of the corruption. And I'm not sure that a new building a new courthouse in Polk County is going to speed up that reform. Perhaps we should have the reform and then talk about a building project. I think that a lot of the um, court sessions probably could be done away with. To have criminals in the same floor and under the same conditions, criminal courts in the same conditions as small claims court doesn't seem to be a whole lot of make a whole lot of sense. They've moved an awful lot of people out of the current courthouse. I know the assessor's office left a long time ago. They've got an administrative building built for them down at what used to be the old city post office. And they've moved the county attorney out of that courthouse. It seems as though that courthouse could function for all of these areas far more adequately than what it is now. But they seem to want to expand services. And the dockets seem to be expanding like crazy. I think if we did the right thing in child protection areas, the dockets would decrease enormously. There's no reason to put a lot of these families through a court session that could be handled in other ways, or perhaps not intervened at all in the first place. I'm looking at a whole long list of recommendations that the Homeschool Legal Defense Organization looked into. Do you have your list, Don? And we're going to go through these before the end of the program. I think these things are very well thought out, and they're backed up by some good thinking on the part of the homeschool legal defense, who have had the real battles with the courts on things other than Fourth Amendment violations. They've had to look into these areas in depth. The one that I was going to start at, number 44, reminds me of another measure that is now already in Iowa law, but there are no enforcement provisions for it. For an example, in fact, there's no enforcement provisions for the idea that social workers must be trained in the Fourth Amendment. And to me, if you have a law and you have no way of assuring that enforcement is going to take place, of what value is the law? Well, the law that I'm speaking about here is one which permits a 10-year-old to block termination of his child-parent relationship. So if you're 10, you can tell the court, I don't want my parental relationship to be severed. I don't know why they have to wait till they're 10, because it's just as valuable, I think, for a 9-year-old or an 8-year-old or a 4-year-old. But apparently 4-year-olds don't have a brain to think with. They can't express their desire to stay with mom and dad, but a 10-year-old can. But here is the problem with that. No one has ever told a 10-year-old that I know of what his rights are. And so we have 10-year-olds who are being taken out of the situation altogether, and can have their rights terminated, not knowing that statute permits them to resist. Well, number 44, Don, is require that states advise any child reporting child abuse against himself of the existing criminal liabilities he faces for making a false report. Require that the states advise any child reporting child abuse against himself of the existing criminal liabilities he faces for making that report. In other words, tell them that if they're going to report child abuse against themselves, that there could be some criminal liabilities for doing that. They don't really care if they can get you to report child abuse. Don, number 45.
Why would a child want to report abuse against himself?
This isn't the child reporting. This any child abuse reporting child abuse. Okay. No, I don't know why. That's a good question. It does say child.
As you said earlier, the child is ignorant about the laws and what are going on.
Yeah.
And the only way they know anything by the time they're 10 years old and in the system for who knows how long is that the social worker and the foster parents teach the child by that time.
That's right.
And so the child really doesn't have any concept of what's happening in the home during that period of time.
Right. Go ahead.
45. Require all social workers to be licensed and bonded.
Did you know, Don, that that's only been in the past few years, and I think I embarrassed a few social workers by saying that in Iowa, the caretaker for pigs is licensed and bonded. He's the veterinarian, but social workers are not licensed, and it has only been in recent years that they were bonded or they were at least licensed. I don't know whether they have to swear out an oath to protect the Constitution. They should, but they don't, as far as I know. But what they did then was they grandfathered a lot of social workers in who did not have the qualifications to be social workers. Require all guardian ad litems to be bonded. I'm not really up on that one, but number 47, Don.
Require that GALs, that's guardian ad litems, conduct bona fide investigations on behalf of the child and make the results of that investigation available to all parties and make the falsification of this investigative report punishable by mandatory fines, imprisonment, and revocation of their license to practice law. Well, in this case here in Iowa, from our experience, the guardian ad litem who represents the child in court, a lot of times, probably 90% of the time, that's just a guess on my part, but a lot of the time has never even talked to the child.
That's right. They wind up in court and say, well, what they're there for is to represent the legal interest of the child, and so they don't have to talk to the child to know what his legal interest is. They know that on their own without talking to the child. And some parents don't even know who the guardian ad litem is. The guardian ad litem has a fairly important role in juvenile court matters because the court looks to them as the real intelligence surrounding this case. No longer do they rely on the parents to know anything about raising their children.
So all the guardian ad litem has to do is shuffle a few papers, file
That's right.
a paper maybe, show up in court, and if they fail to show up in court, well, that's forgiven, I'm sure, and they get paid for all that.
Sure. It's a good business if you're a lawyer that doesn't have any other way of earning a living. Eliminate the requirement for secrecy and sealed records of all unfounded cases and open these records for public inspection so that abuses by the system can be exposed. Well, I think there's times when you wouldn't want all that exposure because it's a general rule that we rely on our public officials to do a good, adequate job, and what they say in lies and threats and intimidations and everything else on paperwork could come back to bite you. So I'm not sure that I'd want to think that one over a little bit, Don.
But if the records are sealed, parents don't have access to it, so they don't even know what's in those sealed records.
That's right.
49. Eliminate the confidentiality protections which in reality are a cloak of secrecy which protects the party in power from having their illegal activities uncovered. And open all records and hearings to the public, censoring only the name of the child and of the parent if they request it. See if they can stand the scrutiny of the public eye.
Yeah, that's interesting. Number 50, require that all falsifications of any records related to child abuse investigations punishable by mandatory fines and imprisonment based upon the standard that the person making the report knew or reasonably should have known that they falsified the report. I think that would be a very difficult one to do, but I applaud him for bringing it up. And require prosecutors to prosecute such crimes vigorously. 51, Don.
Eliminate all instances of heresy.
No, hearsay is correct.
Eliminate all instances of hearsay evidence against the accused in court. So they've got to have, or I'll let you explain it, John.
Okay. This business of second and third party conversations should be completely outlawed. If they can't get it firsthand, then it should not be entered into court.
And especially if it comes from the DHS.
Correct, because they know how to pass information, false information, very quickly. Require that all complaints of the abuse or neglect of children while in state custody and under state care be investigated by both by the CPS agency and by the independent Citizens Review Panel, and that these investigations be conducted independently of each other. Now, that Citizen Review Panel, I haven't seen the specifications for that according to HSLDA, but I'd certainly like to see how they propose to set up Citizens Review Panel. Sound like a great idea. Don?
Require that any child protection agency worker who knew or reasonably should have known a child is being or has been abused, regardless of whether the child is in state custody or not, and or conceals the abuse of the child, and or fails to make action to protect the child, is liable for triple the fines and prison terms as the abuser is subject to for committing the crime, and make the director of this DHS agency ultimately responsible for following through with all reports of abuse, and that the director will be presumed to have known or reasonably should have known of all reports that come into the agency by whatever means. There's a lot of people complaining to the DHS, there's a child being hurt out here, but they don't take care of that either, John.
That's correct. Well, that winds up our time on those particular issues today. There's a lot of things that could be done at the state legislature that would actually cost the state nothing in terms of putting these into law. We'll see you next week.